listening to Driving Law, a podcast by Kyla Lee about all things related to the rules of the road.
Hello, and welcome to another episode of Driving Law. I am Kyla Lee at Acumen Law, and with me, Paul Doroshenko.
Good to see you, Kyla.
Yeah, nice to see
Our
you.
white backgrounds here today.
Yeah. You know what? This is like one corner of my office where I don't have anything hanging. And I do have a piece that needs to go up, so, just a matter of...
That's the back corner of your wall of vein, and we've
Yeah.
left it open for the next awards or what have you. See, there you go.
Well, I do have a stack of awards as well that need to go up.
Waiting things, yes, certificates. Yeah, you taught 3. You presented in 3 classes at a conference recently. You've got lots more to go up.
Yeah.
I have nothing more to go up. But I do have this painting behind me, which is quite nice. I'm in the distillery. I was here bottling today.
I'd just like to point out that on that painting, which happens to be my painting, and I like my art, so I want to make sure that people know that those little floating jellyfishes are just reflections of the lights and not part of the art. Because otherwise it's a weird piece and not in a good way.
No, the lights that we have upstairs in the distillery in our office area. And if you can hear it, there's a printer printing out labels like crazy. And a short while ago, we were feeding we have a mini bottling machine now to fill mini bottles. And our product, Bang On, is selling like hotcakes. They're selling like mini bottles in liquor stores across the province. It's very, very popular. So Bang On.
There we go.
We're filling Bang On this morning. I was feeding the bottles.
Okay.
Yeah.
So I think that we should talk about today, Paul, what I think is the most consequential case that has ever come out in Canada on the drug recognition evaluation program.
Yes, indeed.
Yeah, you might think Bingley was, but Bingley is not.
No, this is quite meaningful and important, and it actually ties into something else that I was dealing with. I did a TikTok yesterday where I laid out how the police officers can unintentionally undermine their ASD demand by making it an option, a choice.
Mm-hmm.
And what people fail to understand is that these processes of investigating people for impaired driving require warrantless searches to be conducted, and the warrantless searches must be conducted in a manner that is authorized by law, because a warrantless search is otherwise unreasonable, and the only authorization in law is the authorization in the criminal code. And that's what that case is also all about, because the authorization is spelled out in the criminal code.
Yeah. So basically, this case involves a guy who is charged. I believe he was actually charged with refusal to provide the urine sample after the DRE evaluation. He was also charged with impaired based on the actual results of the DRE, which of course the results are admissible evidence to prove impairment. He didn't get the benefit of the presumption because of the refusal, but still. And the court found 3 sort of fatal flaws in the case that relate to the drug recognition evaluation process.
Didn't reject the drug recognition evaluation process, which I would love to see. No, but didn't reject the idea of it.
Right. The idea of it, fine. Yes. So basically what the judge said was that there is one 12-step program and one only, I believe it was one and only one was the language used. I'm going to find the quote here. Yes.
So Kyla's looking for the quote. Drug recognition evaluation. Police officers are called drug recognition experts, although I've never seen them publish anything that would make them an expert. But this is the designation in the criminal code. There's certain police officers who have had some training. They go through a 12-step evaluation of the individual who is, that's part of that warrantless search. It's authorized by law. The only authorization in law is to use the drug recognition evaluation 12-step program to assess the person. And then at the end, there may be a circumstance where you're demanding a bodily substance from the individual, and then that bodily substance is tested, and then we have this little magical idea that if the bodily substance matches what the drug recognition evaluator said was going to be there, and the person was impaired on the scale that the drug recognition evaluator had confirmed, then you've established what you need to for the conviction.
Yes. Subject to it being undermined in cross-examination or something.
Obviously.
Okay, so this judge has already written about drug recognition evaluations before, but he cites himself at paragraph 47 of the judgment, which is Rex and Wilson 2026 ONCJ 211, where he says, one cannot approach the two issues without a clear understanding of the legal definition of evaluation in the criminal code sections and the role of an evaluating officer in conducting an evaluation. The primary conclusions regarding statutory interpretation from Takov, his earlier case, are 1. The statutory interpretation of the word evaluation in the criminal code is one and only one very specific evaluation. The 12-step drug influence evaluation, as determined by the International Association of Chiefs of Police Drug Evaluation and Classification Program. In the 12-step DIE, the person who conducts the evaluation is usually referred to as a DRE. A DRE certification covers a number of areas. However, when DREs are acting in the role of conducting the 12-step DIE, their expertise is circumscribed to the role of evaluator as described in the standardized 12-step DIE. Therefore, they have no expertise that allows them to add, change, or ignore any part of the drug influence evaluation or how it is conducted. And 3, given that an evaluating officer under the criminal code and its regulations is a certified drug recognition expert accredited by the International Association of Chiefs of Police, the bullet point above applies to them. So basically, yes, we call it something different in our criminal code and in our regulations, but what is actually referred to there is the official International Association of Chiefs of Police program that they're all trained on anyway.
Yes.
And
Interestingly,
and that you are trained on.
Yes, we've both taken the training, but not the same precise training. We've taken a truncated training because a lot of the training that is part of the DRE is actually not really
Wildly
training.
unnecessary.
It's a filler that taxpayers are paying for.
I would like to know how to use the stethoscope, please.
So, yeah, exactly. So, there's an interesting thing there because, of course, it's laying out these 12 steps, and these 12 steps must be completed because that is what is spelled out in the criminal code. You're going to do a drug recognition evaluation. It's, it's got to be the drug recognition evaluation that's set out by the International Association of Chiefs of Police. And you can't depart from that because if you do, it's a warrantless search that is not authorized by law.
Yep.
And the interesting thing about it on a side that we could get to is part of it's illegal in Canada. But that's a separate issue to be argued on another day. But in this case, the police officer did not do one of the steps.
Yes. So basically what happened, as I said, is he refused to comply with the urine demand. And in the criminal code, in order for the police to make a valid demand for a urine sample, they must prove the statutory preconditions for that demand. So just like you have to have reasonable grounds for a breath demand or reasonable suspicion for a suspicion ASD demand or in possession of a device for a mandatory demand, there are prerequisites. One of which is that if on completion of the evaluation, specifically the DRE evaluation, the evaluating officer has reasonable grounds to believe the person's impaired by a drug, then they can demand the urine. And the court says, paragraph 66, as reviewed above, the evaluation is the 12-step DIE. In the 12-step DIE, unsurprisingly, there are 12 steps. And the officer is responsible for conducting all of the steps, with the exception of step 12, toxicology. Also, as reviewed above, the demand is a demand where the subject must comply with the requirements of an evaluation conducted by an evaluating officer. Step 1 of the 12-step DIE instructs the DRE/evaluating officer to conduct a single breath test. This completes step 1. But the officer in the Wilson case didn't smell alcohol, didn't think alcohol was involved, no admission of consumption. And she said, yeah, I didn't do a breath test because I didn't think that it was an alcohol issue. I thought it was drugs. So I skipped the breath test.
Now,
Step one,
that's one.
not
It's not 10 and a half steps that you do. It's not 10 steps that you do. It's not just 11 steps that you do.
done.
It's 12
Yep.
steps. That is a step that the evaluating officer must do. So you can't even necessarily rely on an ASD test done roadside for that 12 steps.
Yep.
And
Exactly.
if you fail to do that, according to this decision,
And you
which
might think,
is
well,
completely rational,
yeah, well, I don't know. Some people reading this might think, well, the judge is being a little bit pedantic. I mean, if it's not alcohol, it's not alcohol, right? So what's the big deal? But the judge actually explains the rationale, saying like alcohol is in fact a drug. It's a central nervous system depressant, and one of the categories of drugs that the DRE is supposed to identify is CNS depressants. And so doing a breath test helps to either identify or rule out a central nervous system depressant.
what happens if the person's at 50 milligrams or 60 milligrams and that's it?
I mean, in
That's it.
theory, you could
Lots
be
of people are
convicted.
affected.
Yeah,
Smaller.
you could be convicted if you failed the DRE evaluation and you had alcohol because it is still a CNS depressant,
Yeah.
in theory. Now I'm
In-
giving police ideas. Um, and the court also points out that in the training materials, which they relied on for the purposes of coming to the conclusions, the court says step 11, opinion of evaluator, provides only very general guidance of how to form an opinion. For example, that opinion is based on the totality of the evaluation. However, there is one and only one specific direction given in step 11 opinion of evaluator. It is with regard to alcohol. Anytime there is a positive BAC reading during the evaluation, the DRE must list alcohol as part of their opinion. So they have to consider alcohol if it's there, and they can't consider alcohol if it's there if they never take the steps to determine whether it's there.
Exactly. I mean, it is a CNS depressant, and
Yep.
it may be there and accompanying some other CNS depressant, or may accompany a stimulant. I mean,
Yep.
so
And
yeah, there's a reason for
the
it.
court the court says there's no such thing as an 11-step DIE, which is in effect the proposed alternative here. Further, an evaluating officer has no admissible opinion evidence to give if the opinion is based on anything other than the 12-step DIE.
Yeah, which is right back to it's a warrantless search. You haven't got a warrant,
Yep.
so you have to assume that it's unlawful unless it's authorized by law.
Yep.
It will be authorized by law in certain circumstances, provided that it's spelled out in the criminal code and that it is conducted in a manner that is authorized by law in
Yep.
accordance with those requirements. Otherwise, it's a Section 8 violation as a unreasonable search and seizure. And in fact, failing to do that first step would make everything else, and I'm sure the judge didn't go into it because it wasn't necessary, everything else an unreasonable search and seizure because it's no longer reasonable because it's not authorized by law.
Yep. So the judge says this results in Mr. Wilson being not guilty in all caps, which I kind of love. Like, I kind of love that there's like a little bit of like, you can tell this judge is just very unimpressed
A little bit
with
of
the police
cynicism
just
there.
going their own way on what is supposed to be standardized testing for a reason.
Sometimes judges say things that if I were to say in public, I as a lawyer would face some potential blowback. Sometimes they are clever in decisions in cynical ways that I wouldn't be. Sometimes they are use sarcasm. Sometimes they're just a little bit nasty. Some I don't support being. Um, Generally, I think they should be gentle with people, but there's times that I could understand it a little bit. And,
Skipping a
uh,
breath test would take 5 seconds to conduct is,
yeah, I mean, under a minute and might clear up all sorts of things.
yeah. Anyway, the judge goes
Taking
further.
alcohol can make you impaired.
The
And
judge goes the judge goes further in this judgment, though. I don't know if you read the whole thing or if you just read the part I told you about, which was the
I
part.
just went to the sections that you told me about.
Did you read the part about tunnel vision and confirmation bias?
No, but this is something you and I have talked about a million times.
You're gonna love this, Paul. So the judge says
We see it all the time. Like we see it
there,
all.
there's another issue. I raise concerns about tunnel vision and confirmation bias. And then he quotes from the Public Prosecution of Canada's Innocence at Stake report, which has a chapter on understanding tunnel vision, which is, of course, unconscious filtering in of evidence that will build a case against a suspect while ignoring or suppressing evidence that tends to point away from guilt. And that confirmation
That
bias.
in. We should be sending that into the superintendent's office for our hearings.
We should be. Yes.
I've been sending some other things in that I've been finding science on other issues.
Confirmation bias is an element of tunnel vision. It causes an individual to unconsciously prefer information that supports a conclusion that they have already settled on, and to disregard or be overly skeptical about information that contradicts that conclusion, and to filter in evidence supporting their theory and ignore or undervalue evidence that suggests their theory might be incorrect. Confirmation bias causes people to seek, recall, and even interpret data in ways that support their prior beliefs. And so the judge then addresses this issue of the confirmation bias that is built into the DRE process, specifically noting that the officer had basically already formed sequential beliefs that the officer was that the accused was under the influence of drugs, which led her then to filter her observations to support her theory while ignoring contradictory evidence. And one of the things that the court identifies at paragraph 95 of the judgment is what happens when you have indicators of impairment and there's a combination of two categories of drugs. And in the manual, it describes that you can have a null effect where there is when you have two different, like a CNS stimulant and a CNS depressant, where you have like opposite drugs. And so a null effect would be no effect on pulse. No effect on pulse means no effect on pulse. But you can have an overlapping effect where you can have an action and no action. So you can have one drug that will cause pulse rate to go up, one drug that will have no effect on pulse, and the pulse could go up. You can have an additive effect where action plus action makes a greater action, pulse up plus pulse up equals pulse up even more. Or you can have an antagonistic effect, action plus opposite action, which then produces unpredictable results. Pulse may go up, pulse may go down, pulse may be normal. And so the training for the DRE, as you and I both know, doesn't really suggest what to do with those situations. It tells the officer.
Neither does the form. Neither does the form.
No, because the form tells you what the expected result is for an individual category of drugs on its own. But it doesn't necessarily tell you what's going to happen when you have the combined effect of everything. And also, as you know, too, in the DRE, there's lots of categories of drug that produce no effect at all. Like when you have cannabis, for example, the matrix will tell you that on cannabis, no HGN, no VGN, pupil reaction to light is normal, body temperature normal, muscle tone normal, like most of the indicators are going to be normal. So if you perform normal, I've always said if you perform normal on a DRE, it's cannabis. It's no sobriety, it's cannabis. Um, and so that's where you have this sort of potential for tunnel vision. And the court goes through like every single thing that the officer assessed.
Enhanced, I think, because the form is taking you to only answers that are beneficial to come to the conclusion of impairment.
Well, in fact, that's the point the court gets to after going through every single um indicia that the officer assessed, and that a lot of them didn't actually support the conclusion the officer came to. A lot of them were contradictory, and found there was no reasonable grounds to believe that there was a combination of a CNS stimulant and a narcotic analgesic. So also rendered her not guilty on that. But then makes at the end of the judgment, beginning at paragraph 254, additional comments on the confirmation bias and evaluation. And the court came to the view that the officer fell prey to confirmation bias, noting, of course, that she was working alone. She had to form 3 sequential beliefs, specifically the roadside testing, then the evaluation demand, then beginning the evaluation with her prior conclusions in tow. So she'd basically already set the tone for herself by being both the investigating officer and the DRE evaluator. Um, so the task she set for herself was to confirm the specificity of the opinion she already had. Unlike, with a breath test where there's an objective measurement that's done by a machine, and where the breath test might be performed by the person who forms the opinion, but the machine is going to produce the output based on the breath input, not based on the opinion of the person interpreting the results.
I see.
And
Okay.
so, but the court goes further, and it says that of greater concern, given that it could affect more cases than this one, paragraph 260, it is my view that it is a feature in the 12-step DIE that creates a risk of confirmation bias. It is likely a benign feature in most cases, but not in a case like Mr. Wilson's. The feature is step 11, opinion of the evaluator. As explained above, the evaluators were expected to prepare 2 reports. One of those reports, and you and I have seen them, the drug influence evaluation, the face sheet, as it's often called, is a single page, essentially pre-printed, fill in the various parts type of form that records the entire evaluation. They call it in practice the face sheet. The judge probably didn't know that, but that's what it's called. And the court says the feature of concern is at the very bottom. It reads opinion of evaluator, and then there are 10 possible boxes to tick off singly or in combination. They are not impaired, medical, alcohol, CNS depressant, CNS stimulant, hallucinogen, dissociative anesthetic, narcotic analgesic, inhalant, and cannabis. The risk of confirmation bias stems from 2 things in combination. One, a closed list of possible conclusions that have already been settled on. It's a closed list. They don't have an option to fill in the blank to put any other opinion. They don't have an option to say inconclusive. There is no option of inconclusive. And the court says, look, like, I don't disagree that the DRE is a standardized process that's reliable and that it yields reliable results, but there shouldn't always be a result because any reliable test will give negative, positive, or inconclusive results.
These are all good points, and really valuable for any lawyer who's going to be dealing with one of these, and something the police are gonna have to think about across the country. This isn't gonna be one that's dropped, and every once in a while, there is a decision that comes out that all the police are scratching their heads and puzzling about.
Yep.
That's how we ended up losing evidence to the contrary, because there was a case where somebody had exposure to chemicals,
Yep.
and suddenly we lost the innocence defense, um, because of that and a few other things, and I'm worried that the response is going to be to change the legislation in some manner. But that is fascinating right now for all the ones that are in the pipeline. I mean, you can grab all those files out of your desk, every one where they skipped over something.
Yep.
And as you and I know, there is also part of the test that will not pass constitutional scrutiny that the police do in this country that is not permissible pursuant to the charter that nobody seems to have turned their mind to, which we can leave for another day.
Yes. Anyway, I love it. I love it. I think it's a great judgment. I also think that it's an
Good.
important. Hmm?
It's thoughtful. It's great.
Yep. Yep. I think it's important. And actually, sorry, I've been referring to the judge as a man, but I just realized it's a woman. So sorry, Justice Hawk.
Thank you, Justice Hawk.
Yeah.
Whoever.
Also, doesn't it make you think though about the IRP form?
Oh,
That
yeah.
it like applicable grounds for reasonable suspicion, and it gives a closed list of grounds.
There's other,
There's
but
other, but like odor is only
there's
sourced to the breath.
only sourced from the breath. No, I mean, that form is just dying for an attack on the same basis. The problem is that um, we don't see this sort of level of judicial scrutiny of things in BC that we see in sometimes Ontario and Saskatchewan clearly, and occasionally in Alberta. We just
Yeah.
don't see it in BC.
Yeah.
As I said, BC is everybody thinks BC is very liberal and very uh, very progressive, and in many ways we are more fixed and more likely to defer to government than other parts of the country. I'm less skeptical.
Yeah. Yeah.
Okay,
Anyway, so there you go. I'm like already plotting the many ways in which to
I know you are.
use this to. It's fantastic. You know, it's gonna appeal though.
It'll be appealed, but that could be upheld. They might
Did you hear
chastise.
me? They're gonna appeal?
I'm sure they will
Yeah.
appeal. As
I
they
mean,
might chastise the judge a little bit for it, but it's pretty rational, at least on the missing the one step is missing a step, and that's it. I mean, you're talking about a refusal,
yeah,
which
just do the
again,
fucking
the
drug
demand is
test.
only authorized by law if it's meets all the requirements. Police officers don't often get this, but it almost never, if there is a charter violation leading up to an approved screening device demand or test, the results will not be admissible because it is already constitutionally deficient and only upheld by Section 1. And all of this stuff is tenuously constitutional, and it's compelling the person to participate in providing the evidence. We don't really rely on that test that much anymore because since the Stillman analysis was turfed by the Supreme Court of Canada, but it is still a feature to consider. And so when you don't do it, you don't follow the steps, or you do something wrong that takes it outside of that authorization in the criminal code, you can assume that it's not going to be admissible.
Mhm.
Or
I mean,
Chad Kruger.
if you're gonna create a process whereby you can do a warrantless search of somebody's body, or in this case, basically a full-on medical evaluation, right? You're checking people's pulse, pupils, blood pressure, heart rate, you're taking them into a dark room,
Hugely,
you're feeling them up. Like if you can do all of those things
hugely intrusive.
and to somebody hugely intrusive, and then possibly take their blood or their urine out of their body after by compulsion, you'd better adhere to the requirements strictly. Like this has to be high because it is so invasive.
Exactly. All right. I think
All right.
I
That's
don't know if you
ate up
think we
most
have
of our
another
podcast time, but I think
good chat.
there's a weird way. Yeah. Yes, we have a ridiculous drive now.
We do have a ridiculous driver. I sent it to you on Slack.
Are you there?
Uh, I'm here and I can hear myself,
Yes.
hoping that it's still recording. I can tell you about the ridiculous driver if you would like. The ridiculous driver is actually two kids. This was in the southern US. I don't know where. I don't have it in front of me, but it happened just this week. And they decided that they wanted to make some viral videos. And we see, of course, more and more people doing stupid things trying to make viral videos. These two decided that they would drive a riding lawnmower into a Target store,
This one does.
dressed as old time
Hmm.
farmers, and drive around the Target store and then drive out. Now, I only saw one person in the video. The video wasn't the video that was shot by the cohort, these two working together. But other people, of course, pulled out their phones and started recording. And you could see that, first of all, he struck the door of the Target store and damaged it on his way in. Then went driving around in the aisles, and again, straw hat on and coveralls. And they're 18 years old, two 18-year-old. Boy, smart, typical the wisdom of the 18-year-old, and drove around the target and then drove out in this on this riding mower. So they were both arrested, and they both got bonded out, which means they got bail by their family, but they're both facing criminal charges, and their mugshots are up there on the internet, and you see their haircuts, and you're like, well, suddenly you're like, oh yeah, I remember being 18 and stupid. Well, they were 18 and very stupid. So they are ridiculous lawnmower drivers of the week. And there was a number of good choices. It just felt like the one.
Of the week. Probably find the video on social media, wherever you get yours. And that's our podcast. So if you have a driving law related issue, you can find us online at vancouvercriminallaw.com or give us a call at 604-685-8889 and tune in next week for another exciting episode of Driving Law.